Let's look at the case of Rylands against Fletcher, which is considered to be a strict liability case. The exact citation is John Rylands and Jehu Horrocks, plaintiffs in error, and Thomas Fletcher, defendant in error. Brief facts of the case are as follows. The defendants were the owner of a mill. In order to improve the water supply to the mill, they employed some independent contractors, who were apparently competent engineers, to build a reservoir on their land. During the course of their work, the contractors discovered some underground passages and mines which were filled with debris. Despite being aware of their existence, the contractors did not seal the mines and shafts and carried on constructing the reservoir. The result was that on 11th of December 1860, shortly after being filled for the first time, Rylands Reservoir burst and flooded a neighbouring mine run by Fletcher, causing £937 worth of damage. The defendants were held liable for the damage. Let's discuss the rule in Rylands and Fletcher. The rule was stated by Blackburn J in the following terms. The person who for his own purposes brings on his land and collects and keeps there anything likely to do mischief if it escapes must keep it in at his peril, and if he does not do so is prima facie answerable for all the damage which is the natural consequence of its escape. Although decision was made by Blackburn J at the level of the Court of Exchequer Chamber, comprising of 6 judges, the final authority was that of Lord Keynes and Lord Cranworth at the House of Lords. This rule was approved by Lord Keynes. Lord Keynes also added the requirement that the use of the land must be what was called non-natural use. Lord Keynes gave the meaning as that which in its natural condition was not in or upon it. This was criticized by the academicians and judges in various jurisdictions. This was further clarified and restricted in the later cases and is now understood to be non-natural use of land. Lord Cranworth summarized the principle as follows, the second Lord in the House of Lords. If a person brings or accumulates on his land anything which, if it should escape, may cause damage to his neighbour, he does so at his peril. If it does escape and cause damage, he is responsible, however careful he may have been, and whatever precautions he may have taken to prevent the damage. Let's discuss now constituents of the rule. Number 1 is things brought on the land. In his judgment, Blackburn J referred to bringing things on the land. Thus, the things which grow naturally on the land, for example, thistles in the case of Giles against Walker, or are accumulated naturally, are not covered by the rule. Moreover, the use should be non-natural, that is, not something that is naturally on the land. As in the case of Mason against Levy Auto Parts of England Limited, the defendants accumulated large quantities of combustible material. As a result of ignition, under some mysterious circumstances, fire broke out, which resulted in a damage to the claimant's premises. Clearly, this combustible material was not naturally on the land. Second constituent is escape. The thing must escape from the defendant's land. If there is no escape, there is no liability under the Rylands rule. Third point is occupation. Blackburn J envisaged that the defendant would be in occupation of the land from which the thing escaped. Some later authorities suggest that if the owner, who is not in occupation, may be liable if he authorized accumulation of the things on the premises. Fourth constituent is foreseeability of damage. In the case of Cambridge Water Co. and Eastern Counties Leather plc, the House of Lords made a fundamental change to the rule and held that foreseeability of damage was an ingredient of the cause of action under Rylands. And finally, who can sue? Normally, the owner, occupier of the land can claim damages under the rule. Damages in respect of personal injury and economic loss, etc. have been controversial. And finally, in this video, let's look at the defenses. regarding Rylands and Fletcher case. Number one is act of God or force majeure. The term means an act which is beyond a human control and which no human foresight can provide against. For example, some loss due to flooding, extraordinary rainstorm, etc. Second defense is consent of the claimant, where the claimant has consented for a thing to be brought on the land of the defendant and then suffers damage as a result of the escape of that thing. The claimant may not be able to claim damages for the loss. Third defense is common benefit, where the defendant and the claimant both benefit from the source of danger. Defendant will not be liable. Fourth defense is independent act of a third party. For example, the case of Perry and Kendrick Transport Limited illustrate this. A boy, aged 10, got injured after his friend ignited a fuel tank of a disused bus. Assuming that the damages can be awarded for personal injury, the Court of Appeal held that the claimant failed to establish that the act of removing a fuel cap by a third party could have been reasonably anticipated and guarded against by the defendant. In this case, it wasn't. And the final defense is statutory authority. If an act is being done under a statutory authority, no liability will be under this rule. Cause of action may arise under common law of negligence, though. Some books seem to suggest that in a House of Lords, in this case, 3 judges decided the case. For example, see Tort Law, Text and Materials by Lunny and Oliphant, 3rd edition, where they have stated that another historical aside of interest is the identity of the third law lord who decided the case alongside Lord Keynes and Cranworth, who appears to have been the Bishop of Armagh. This appears to be the reference to Lord Colonsay. However, as per Simon 1984, page 250, he had failed to attend, and the report itself does not mention the name of the Lord Colonsay. The decision was recorded by only 2 judges and was not decided by Lord Colonsay as asserted by Lunny and Oliphant. There was another term which was under considerable debate, and that is non-natural use of land. This was considered by the House of Lords in the case of Transco plc and Stockport Metropolitan Borough Council, for which please refer to a separate video. Thank you.